So this question I'm going to ask, there's a reason why I'm asking it here. It sounds like a technical question and it sounds like a very pedantic question, but ultimately I would say this question, if whatever the answer might be, is going to have a huge impact on potentially tens of thousands of people every year. And it basically, it's around the thresholds that people have to meet to kind of get certain levels of assistance from a local authority. So as I say, my question is long. I can't make it any more succinct, unfortunately. Hopefully it will make sense. So under Section 184 of the Housing Act, if someone approaches any department of a local authority and gives them reason to believe they might be homeless, they immediately trigger Section 184, so that the council then has to make inquiries, reach a decision, issue that decision in writing, and so forth. Now, there was a case back in 2007, I think, Owies v Birmingham, where essentially the judge in that case said it is almost impossible for a council to be approached for homelessness assistance and that duty is not triggered. So essentially, if someone turns up, says I'm homeless, or they said I'm experiencing domestic abuse, or I can't afford my rent, all those things would potentially, well, they would give the council reason to believe the applicant may be homeless, and therefore Section 184 proceeds. And then this is the kicker. So that was all a prelude. Section 188 basically states that if an applicant may be homeless, may be eligible, and may be in priority need, the council shall provide, make sure that accommodation is available for them. And this is where my question comes. Various cases have shown that pretty much any mental health issue, to use that example of mental health issues, could lead someone to being vulnerable and therefore in priority need. So my question, just a classic example of that would be Thomas v Lambeth, where the applicant had depression, been diagnosed with depression, and she was found to be in priority need. Now, so here's my question: if someone approached the council, said they were homeless, therefore giving the council reason to believe they might be homeless, and they basically said they had a mental health issue, or they'd been in care when they were a child, or they just left prison, or all those kind of categories that could make someone in priority need, would that in itself cross that Section 188 threshold and give the council reason to believe that they might be in priority need? My question is how high is that threshold, or how low is that threshold that a person would need to, because things, I'll give you some examples, and I will labour this point. My colleague John accompanied a pregnant lady. She was, I think, 30+ weeks pregnant, visibly pregnant, and she told the officer that she was homeless. And the officer said, okay, well, you're going to need to show us a pregnancy test before we can help you out. And then so they did that. They jumped through that hoop, and so the officer said, no, that's not enough. I'm going to need to see the green book from your midwife before I'm going to accept that you might be in priority need. And so they did that. And then the officer said, no, I'm going to need to see a scan photo before I believe that you might be in priority need. Now, that's the reason I'm asking this question, and in one sense, that's the kind of the background of it. So again, it sounds very pedantic, but how high is that threshold, or at what point would a council have reason to believe someone might be in priority need?
Yeah, and I wonder if you want to go first.
Well, the first thing for me to say, Mike, is that your question wasn't pedantic at all. But if you ask 3 lawyers that question, you may get a very pedantic answer. Yeah. And even more infuriatingly, if you ask 3 lawyers, you may get 4 very different answers. So let me have a first stab. Mike, in your question, you raised the references to a large number of sections of an Act of Parliament. The Act of Parliament you're speaking of is the Housing Act 1996, and Part 7 of that Act sets out the responsibilities of local councils in relation to homelessness assistance. I know you know that very well, but I thought that mentioning that would set a platform. Now, Parliament has decided that the questions about who gets what help should be decided by local authorities, and therefore the legislation uses quite frequently the term "the local authority is satisfied that." So the local authority is satisfied that you are homeless, you are in priority need, your accommodation is suitable or unsuitable, or whatever it is. That's the decision-making level. But as you rightly say, before anybody makes any decisions, they have to start their investigations, start their inquiries. And therefore, Parliament has fixed the trigger for the commencement of inquiries much lower than the decision-making level, because obviously one's got to look into things. And that is why the words you have used, reason to believe, have been adopted at that threshold level rather than the higher standard satisfied that. So in the government's code of guidance, which explains to local authorities how this all works, each time there is guidance given on the meaning of the words reason to believe, the guidance draws a contrast to the higher standard of satisfaction. That's when you know something and you can decide something. So take an example that you've just mentioned, not the specific case, but the generality. A person will be in priority need if the local authority is satisfied that they are pregnant, or they live with somebody who is pregnant, or they can reasonably be expected to live with somebody who's pregnant. Now, those are three discrete categories of priority need. You can get priority need for one of those if the local authority is satisfied. But in order for the local authority to know that, there's got to be an inquiry and investigation process. And all you need to raise in order to raise that question is reason to believe that you may be pregnant, may be living with somebody who's pregnant, may be a person who might in the future live with somebody who's pregnant. So one can see why in cases such as those you've mentioned, the judges have had to spell out that this is an extremely low threshold. It's just a trigger to looking into the question. So when I used to do training on this sort of thing, I always used to give the example of the person, take an example of a male who walks up to the counter and says, "Give us a house, mate, I'm homeless," and then keels over. That person has made an application for housing or for assistance in obtaining it, and has given the officer reason to believe they may be homeless because they said they were. So that seems a very silly example, but I would say it applies in exactly the same way in a scenario, for example, of pregnancy. You go up to the counter, you're visibly pregnant, you say you're pregnant, well, that gives the officer reason to believe. One would think. Of course, there are going to be exceptions. There is the person who's going to come up to the counter with a large belly and say, "I'm pregnant," and the officer is going to say, "Aren't you the same woman who did this last week and then took 3 pillowcases out of your t-shirt?" Of course, there are going to be the extraordinary or exceptional cases like that. The person who is known to be an inveterate liar and so on and so forth, that they can be put to one side, but they are a tiny fraction. The general message is this is a very low trigger point for the starting of inquiries. And as you rightly said, if you might also give the local authority reason to believe that in addition to possibly being homeless, you are also possibly in priority need, then that triggers a duty to provide you with accommodation while the issue is being looked into.
Thanks very much, Jan. That's really helpful. Is there anything else you want to add to that, Sarah?
Yes, well, there are two slightly different trigger points here. So there's the trigger point for commencing inquiries, and that is extremely low, as you referred to, Mike, in our ways, and also in another case called Berry and Gibbons. It was said that by the mere fact of you making an application for housing assistance, you are already providing that trigger for inquiries to have to commence. There was a case a couple of years ago called Edwards and Birmingham, which asked all sorts of bizarre questions like, could you approach the refuse collectors? Could you turn up at the local authority leisure centre, and so on? Well, I mean, of course, those are extreme examples, but if you're going to the right place and you're saying you're homeless, really, the local authority has got to start investigating. It's only a very short step further to then get to the point that there is also a duty to provide accommodation. Now, the duty that you referred to under section 188(1) of the Housing Act is what is commonly referred to as the interim duty to accommodate. So it's the duty to provide accommodation or to arrange accommodation precisely before the local authority has made its inquiries, precisely before it has investigated the truth or otherwise of what you're saying, or the severity of your symptoms, or whatever else. And so for that reason, the courts have have always said that it was a designedly low threshold, and of course it is. It's very difficult in cases of vulnerability, as opposed to pregnancy, for example, to it's very difficult to draw any sort of hard and fast rules about what is going to cross that threshold and what isn't. But bear in mind that the comparison that is being made when we're looking at whether a person is vulnerable is between a person who does have the condition that is being claimed and a person who doesn't. So if you have some sort of condition which may impact on your, I don't want to say ability to cope, because that's not the test, but which is relevant to your homelessness, let's put it that way, so that you might be at a risk of some form of harm whilst homeless, then that's likely, I suppose, to cross that threshold. But we can't really say that the mere fact, for example, that you say I have depression or I have high blood pressure on its own, it might be enough, it might not be enough, and it's very difficult to say without knowing the facts of any particular person's case.
So essentially, you're saying there would need to be some some kind of impact that depression might have on that particular person at that particular time for that to kind of start becoming a question for the of whether they've reached that low threshold. Is that? I
like I say, I don't want to sort of say too much about it. What I think I mean is that the mere label on its own is probably not enough, unless it's a label which sort of by definition is going to affect a person's ability to deal with homelessness. So I don't know, for example, somebody who's got ME or somebody who's got cancer or something where it's abundantly clear that the mere fact that you have that condition is going to make you vulnerable. But in very many cases, of course, that's not what we're talking about. So there would need to be, I think, a little more than merely reciting the fact that you have this particular condition.
Yeah. Okay. I mean, Araba, do you want to add anything to that? I mean,
you're going to get two lawyers agreeing, which is a novelty. But the point that I really wanted to pick up with is this obligation to provide temporary accommodation whilst inquiries are carried out. And we know that often what happens is people don't look at the person and see, oh, is this person giving me reason to believe that they might be homeless? They're thinking, we don't have temporary accommodation. And so there's really looking at I think the threshold is very low, which I think can be a great burden for local authorities and for housing officers who are aware of the general context. So I think that's often where you get people being sceptical of a lady who is 30 weeks pregnant and saying, no, I don't believe it, I don't accept that. And that's probably where it's coming from. So I think what you often get is not the application of the law strictly in the strict sense, but you get people who are in the sector, who are aware of the restrictions in the sector, aware of the shortage of accommodation, whether it's temporary accommodation or suitable accommodation once people have been through the process, where sometimes you feel perhaps people have, I mean, I know we deal at Just Us with, I think, 11 local authorities, and you know that there's an issue of people coming over the parish boundary, so to speak, and they've come from central beds, they've come from Northampton, and they're in Bedford looking to make a homelessness application. And so one sympathises with the pressures on the system that encourage housing officers to feel, well, I'll start from the wrong end. But I think the threshold is very, very low. Certainly vulnerability is very difficult to assess. The known categories of priority need are often very obvious. I think you sometimes have issues with mental ill health because that too is on a vast spectrum. And somebody who comes in floods of tears may or may not be suffering from depression and anxiety. They may just be suffering the inevitable stress that we would all suffer if we're being evicted. Are they in that category of vulnerable person that this is directly related to their homelessness, would make them less able to cope with homelessness than another person? And I think those things do make it very difficult to assess. But yes, the threshold is deliberately low, when you've made your inquiries, then you can say, having made those inquiries, not satisfied. I think actually getting over the threshold, it should be much more straightforward and much more common. And we know the pressures everyone's under. I just wanted to say something in relation to what Jan said earlier about being the letting agency for the private sector. And it is really a very big issue, because we know that even temporary accommodation is often councils paying private landlords. And it's often that accommodation isn't suitable, but may nevertheless be very expensive. So I think that the issue of the shortage of social and public housing available, including for temporary purposes, is one of the very big drivers.
Mike, I wonder if I could say something about the remedy in those sorts of cases that you're talking about, because sure. You said earlier when you were giving your introduction that when you first started looking into homelessness, you didn't really realise that homelessness law was a thing, that it existed. And I think that seems to be an issue that a lot of people have, that actually you go to the housing options office and you get turned away, and it doesn't occur to most people that that is a decision that could be challenged. So if I can give some sort of advice or reassurance, it's that those decisions can be challenged. They frequently are challenged, and cases like your client that was visibly pregnant, they are clear-cut cases that we would be on the phone to a High Court judge to get an order that day that there would be accommodation provided for that person. And these sorts of gatekeeping cases form a very large part of urgent applications to the High Court, because really, if you're going to be phoning up a High Court judge in the evening, you really want your case to be incredibly clear-cut and straightforward. You don't want it to be anything complicated. You don't want to have to argue for any particular interpretation. And those cases, like the pregnant applicant, that is what we deal with, and there is a remedy available if only more people knew that it was there. Yep.
And I'm hoping, I mean, I know there's a real mix of people watching tonight, but I think there's I'm hoping that this is real kind of, music to the ears of people who are, voluntary sector workers who won't have ever heard of this stuff. And again, are often quite intimidated by the thought of challenging council decisions.